SCOTUS required cases presentation. Alejandro Castillo and Mark Kendrick Ceballos. Marbury v. Madison, 1803. The U.S. Supreme Court first declared an act of Congress unconstitutional, thus establishing the doctrine of judicial review. The court held that although legally the commission should have been delivered, the clause of the Judiciary Act of 1789 enabled Marbury to bring the case to court was unconstitutional. The court decided that it would be unconstitutional for it to issue a right of mandamus as an original action because doing so would violate Section 3 of the Constitution. Congress did not have power to change the Constitution through legislation because the Supremacy Clause places the Constitution before the laws. There was no dissent.
McCullough versus Maryland, 1819. The court decided the federal government had the right and power to make a federal bank, and that states did not have the power to tax the federal government. The Supreme Court said that Congress has implied powers de- delivered no, what from those listed in Article 1, Section 8. The proceeding posted two questions. Does the Constitution give Congress power to create a bank, and could individual states ban or tax the bank? Marshall ruled the favor of the federal government and include the power to tax individuals, the power to destroy. A case in which the court decided that the second bank of the United States could not be taxed by the state of Maryland.
Schneck versus U.S., 1919. Charles Schneck was charged under the Espionage Act for mailing printed letters of the military draft. The court ruled that freedom of speech and freedom of the press under the First Amendment could be limited only if the circumstances presented a clear and present danger. Speech creating a clear and present danger is not protected under the First Amendment. Oliver Wendell Holmes upheld Schneck's conviction and ruled that the Espionage Act did not conflict with the First Amendment. If speech is intended to result in a crime, the First Amendment does not protect the speaker from government action.
Brown versus Board of Ed, 1954. The Supreme Court ruled separating children in public schools on the basis of race was unconstitutional. Decision in the Brown and Board of Education case declared the separate but equal. States, Sam, I said, state
Sanction.
separation of public schools, which was a violation of the 14th Amendment and was therefore, I can't see that, untrue. You see that? Therefore,
Untolerable.
untolerable. Was a landmark decision of the U.S. Supreme Court that ruled the U.S. state laws. I can't see this.
Establishing.
Establishing racial and separation in public schools are wrong, even if the separated schools are otherwise equal in equality. Our Constitution is colorblind and neither knows nor tolerates classes among citizens.
Baker v. Carr, 1962. The U.S. Supreme Court case that held the federal courts could hear cases alleging that a state's drawing of electoral boundaries violates the Equal Protection Clause of the 14th Amendment. The Supreme Court reversed, finding that finding that the subject matter of the case was within the federal judicial power. Each vote should carry equal weight regardless of the voter's place of residence. They ruled that federal courts have the authority to enforce the 14th Amendment if the state legislative districts are disproportionately populated. The case was judiciable and did not present political questions.
Um, Ingle versus Invalidity, 1962. The court held the responsive decision to use its school system to of the official prayer violated ins- blah. The state cannot hold prayers in public schools even if part part how I can't pronounce it is not required and the prayer is not tied to a part religion. The the minority hold the school sponsored prayer violates the is it
Clause, establishment clause,
clause of the First Amendment. The court ruled that it is
constitutional.
constitutional for state officials to compose an official school prayer. Justice Stewart argued in his dissent that the it's how I can't say it.
Establishment.
It's that I can't like pronounce it. Cause was only meant to prohibit the
Establishment.
of the state-sponsored church and not
Prohibit.
prohibit all types of government involvement in with religion.
Gideon versus Wainwright, 1963. The Supreme Court ruled unanimously in favor of Gideon, guaranteeing the right to legal counsel for criminal defendants in federal and state courts. The Constitution requires the states to provide defense attorneys to criminal defendants charged with serious offenses who cannot afford lawyers themselves. The court held that the Sixth Amendment guarantee of counsel is a fundamental right, guaranteeing the right to legal counsel for criminal defendants in a federal and state courts. It is not to be thought of in a civilized community for a moment that any citizen put in jeopardy of life or liberty should be debarred of counsel because he was too poor to employ such aid.
1969 Tinker versus the DS something. The court found that the First Amendment applied to public schools and schools officials could not censor student speech unless it's disrupted. The the inter, the educational process submitted students' rights to free speech in public schools. The Supreme Court majority ruled that neither students nor teachers shed their constitutional rights to freedom of speech or expression of the schoolhouse gate. Students' peaceful protests through wearing armbands was protected under the First and 14th Amendment. The court took the position that schools officials could not permit it only on the feeling that the speech might disrupt the learning environment. The First Amendment did not grant the right to express any opinions at any time.
New York Times versus United States, 1969. The court ruled 6-3 in New York Times versus United States that the prior restraint was unconstitutional. The government's power to censor the press was abolished so that the press would remain forever free to ensure the government. The right to publish all statements is protected under the First Amendment. The court ruled that the president's attempt to prevent the publication was a violation of the First Amendment protections for press freedom. The Times should have discussed the possible societal repercussions with the government prior to publication of the material.
Wisconsin versus Yolderd, 1972. It established the right of parents to control the religions of their children without state enfranchisement. The court held that individuals' interest in the free exercise of the religion under the First Amendment outweighed the state's interest in completing completing student school attendance beyond the eighth grade. A state law requiring um, children to attend schools full time was on, on because it's infringement on the freedom of the what does it say a niche to practice their religion. Individual interest in the free exercise of a religion under the First Amendment outweighed the state's interest in what's the same thing. Uh, Justice William O. Douglas dissent in part from the Maher.
The court, Shaw vs. Reno, 1993. The court found that when it comes to redrawing voting districts, Ray could not be the deciding factor. The justices decided that using racial reasons for redistricting is unconstitutional. The court ruled that claims of racial redistricting must be held to a standard of strict scrutiny. Shaw failed to present cognizable harm, or that for Shaw to bring the case there must have been harm done to them one way or another, and that this failed to be presented in court. The group claimed that the streets were racial gerrymanders that violated the Equal Protection Clause of the 14th Amendment.
U.S. versus Lopez, 1950, no, 1995. The positions the possessions of a gun in a local school zone is not an economic activity might do that, that might do repetition anywhere have a substantial effect on in, insert state concern. Gun gun possession is not a epic uh, activity that has any impact on a insert state, whether direct or indirect. So the federal, the federal government can cannot base a law prohibiting gun possession near school on the Commerce Clause. Gun possession is not a, a economic activity that has any impact on the insert state. Where am I at? Congress had extended its constitutional authority under the Commerce Clause when it's passed a law prohibiting gun possession in local school zones. Justice Stevens argued that Congress Commerce power enable it's not only to prohibit the guns in schools, but it's prohibit them anywhere.
McDonald versus Chicago, 2010. McDonald versus City of Chicago case is which in which on June 28th, 2010, the U.S. Supreme Court ruled 5-4 that the Second Amendment to the U.S. Constitution, which guarantees the right of the people to keep and bear arms, applies to state and local governments as well as to the federal government. The Second Amendment right to bear arms is applicable to state and local governments through the 14th Amendment. The Due Process Clause affirmed an individual's right to possess firearms for self-defense under the federal law. The McDonald decision has had a profound impact on the interpretation of the Second Amendment and on the regulation of guns. Disagreed that the 14th Amendment incorporates the Second Amendment against the states.
Citizens United versus FEC, 2010. The majority opinion was written by the Margaret Justice Anthony Kennedy, who chose to ally with the more uh, justice. The court held that can't read that. Wait, BCRA selections 203 permit of all the independent political and okay, hold on. It violated the First Amendment protection of free speech. The court immediately hold in this case that the anti-corruption interest is not su- to displace the speech in question from Citizens United and the independent um, expand. I can't see. Okay, including those I can't see made by corruptions do not give ra- race to corruption or the appearance of corruption. On January 21st, 2010, the court issued a 3-4 decision in favor of Citizens uh, United that struck down the BCRA restrictions on the independent political instance by by as by, as violations of the First Amendment and reversal of the district court opinion. Justin, no, Justice Paul John Paul Stevens argued that the court ruling represents represented a rejection of the common sense of the American people who have recognized a need to prevent prevent um, pop- from the undermining self government.